Hello, my name is Dana Stetson. I'm your business broker. When I first meet a seller or buyer that is considering the sale or acquisition of a business, one of the early questions I have is, have you engaged an experienced business attorney? As this will have an important impact on how smoothly and safely the transaction proceeds. The purchase or sale of a business can involve a number of legal issues, including asset purchase agreement, review and assignment of leases, representations and loyalties, non-compete and non-solicitation provisions, seller financing documents such as promissory notes and security agreements, corporate formation and ownership documents, employment and independent contract agreements, landlord, lender, and third-party consents, closing documents, and post-closing obligations. These points are integral to a successful business sale. I will always bring in an accomplished business attorney to assist the buyer or seller in properly documenting and protecting their interests throughout the transactions. To discuss the best practice of working with a business attorney in the sale or acquisition of a business, I've invited James Dibbini of Dibbini & Associates to provide an overview of the legal process. Jim, please introduce yourself and your firm.
Thanks, Dana, and thanks for having me today. So I'm James Dibbini, founder of James G. Dibbini & Associates. I've been practicing 28 years, and we're a Westchester-based law firm focusing on businesses and real estate transactions, landlord-tenant law, and litigation. A big part of what we do is helping clients buy and sell businesses, making sure the deal actually works legally, not just on paper. In other words, we're trying to make sure nobody wakes up the next day after the closing saying, wait, what did I just sign?
So what are the first questions you ask a buyer or seller when they're preparing for a business transaction?
A great question. So the first thing I ask is, what exactly are you buying or selling? You'd be surprised how often that's not totally clear. Is it assets? Is it stock? Is it goodwill? Or is it just a name and a phone number? Then I ask, what are you trying to accomplish? Because the legal strategy is very different if you're retiring versus expanding versus just trying to get out quickly. And finally, my favorite question, what keeps you up at night about the deal? Because that's usually where the real legal risks are hiding.
That makes a lot of sense. What are the most important terms in a purchase agreement that buyers and sellers should focus on?
What's being bought or sold? Sounds obvious, but this is where the fights happen. Secondly, representations and warranties. Basically, what promises are being made about the business? This is where liability lives. Thirdly, indemnification. Who pays if something goes wrong after closing? I always tell clients the price gets all the attention, but the terms are what determines whether you keep that money.
How do you deal with situations where there's a problem that wasn't really identified by the buyer or seller initially?
It depends on what that is and whether we are at the LOI stage or whether we are actually in contract, whether our contract has a due diligence provision. So it really varies on what the circumstances are.
How do you approach lease review, lease assignment issues when the business operates from a rented location?
Well, very carefully, because the lease can make or break the deal. We look at whether the lease can be assigned, whether the landlord consent is required, usually it is, and whether the landlord is going to use this as an opportunity to renegotiate everything. That happens sometimes where the landlords could make life difficult for the buyer and the seller and are pushing for a change in the lease terms to better benefit the landlord in order to make the deal go through. I tell clients all the time, you're not just buying a business, you're inheriting a relationship with a landlord. And sometimes that's the scariest part of the transaction.
Great. Jim, how should buyers and sellers think about non-compete agreements and seller transition obligations?
Well, both issues are very important, I must say. From the buyer's perspective, you're paying for goodwill. So you don't want the seller opening up across the street next week. From the seller's perspective, you want the restrictions to be reasonable in time, in geography, and in scope. So as for transition, I always say the smoother the handoff, the more valuable the business actually is. And sometimes the seller's sticking around for a bit is worth more than anything written in the agreement. Having that seller transition over, being able to assist with customer relations and a smooth handoff to the buyer being able to rely on the seller to answer some questions that pop up days or weeks after the closing are just priceless.
When seller financing is a part of the deal, What documents and protections should be in place?
At a minimum, you're looking at a promissory note, right? So the buyer would have to sign a promissory note promising to pay whatever that financing obligation is. Secondly, a security agreement, because the note by itself is useless without the ability to secure it against something, whether you're securing against stocks, you're securing against inventory, you're securing against equipment, you're securing against accounts receivable, and likely a personal guarantee. You don't want just a company to be the signer of this note. You want it to be able to be backed by someone's personal good faith efforts. And what we want clearly defined what happens if there's a default. So because everyone is optimistic at closing, but the documents need to be, you need to plan them for when things go sideways on a deal. You want to be able to have that all lined up and ready to go.
This is why we hire attorneys, is for the case where not considering the negative aspects. Like the buyers and sellers are always considering the positive aspects, not just in business sales, but in other transactions as well. That's pretty important.
I'll defend myself as an attorney in that respect, because some attorneys may be known for killing a deal, but that's not the approach we take. We'll advise, we'll educate, but our goal is to work with the client and what their wishes are, and find creative ways to accomplish, the legal protections without killing a deal.
Well, that's important, that's for sure. What due diligence items are most often overlooked by buyers?
That's a big one. Financial verification and licensing requirements. Buyers sometimes really rely too heavily on what's presented without digging deeper. So they'll just take a piece of paper that comes from the seller, but without digging into those numbers. And that numbers are supported by tax returns and supported by deposits and supported by, expenses and so forth. So you, as a buyer, you really want to do your due diligence in that respect and find multiple ways to support the financial numbers. If that includes going to the location and working there and physically observing with your own eyes as to what's going on to help support your overall satisfaction level, that's important. Tax issues are important, existing liabilities, and employee or contractor misclassifications. And one I always emphasize is litigation history. You don't want to inherit someone else's problems. So you want to make sure there is no litigation pending with respect to that company that you're purchasing, or the assets of the business that you're purchasing.
So at what point, Jim, in the process should a buyer or seller bring in an attorney?
Well, I say as early as possible. Ideally, that buyer, that seller, you want to have a relationship with the attorney early on, like you want to have it with your accountant, like you want to have it with a good broker like yourself, Dana. Before you're signing anything, you want that attorney on board. I can't tell you how many times someone calls me after signing a letter of intent and says, hey, it's not binding, except for these 5 things that are now a problem. So getting counsel involved early actually saves time and money and avoids having to fix these things later on down the road.
Okay. Are there special considerations when the transaction involves related real estate, landlord issues, or lender representation?
Absolutely. When real estate is involved, you really are doing 2 transactions, if not more, at one time. You have the business deal, and then you have the real estate or the lease component. Not to mention if you've got a franchisee-franchisor situation involved, that complicates it even more, but I won't go into that. And then plus you have lenders who will have their own requirements and documents and timelines. So coordination becomes critical, and you really have to juggle a number of things at one time in order to march forward with a clear goal in mind and being able to close this deal. So that's important, keeping in mind that you have the lender's issue, you have the real estate aspect, whether it's a lease or a purchase, and the business aspect of itself, and that could also involve a franchise situation.
Yeah, that's very insightful, because what we see in many cases, buyers and sellers only do this once in their lifetime practically, whereas you're doing this daily, weekly, and a lot of these points you raised, buyers and sellers that may be very good business people, but has never done it before, and these kind of points are mission critical. Thanks for raising them.
Sure.
So Jim, any final thoughts for buyers or sellers that are considering a purchase or sale of a business?
Sure. I mean, don't treat this like any other transaction. For most people, this is one of the biggest financial decisions that they'll ever make. Surround yourself with the right team early on. Good broker, like I said, such as yourself, Dana. A good accountant, and yes, a good attorney. and take the time to do it right. Do your due diligence, because a well-structured deal doesn't just get you to closing, but it protects you after the closing as well.
Great. Jim, thank you for your insight and your time and your valuable thoughts.
My pleasure. Thank you very much, Dana. All the best.
And again, my name is Dana Stetson, and I'm your business broker.